Thank you, Jez. I hope you can all hear me. Welcome, everyone. Really welcome and very pleased to see such a large audience gathered for this webinar in relation to the Australian Law Reform Commission's inquiry into the Future Acts regime in the Native Title Act. I'm joined by Tony McAvoy, to whom I'll hand over shortly. Tony is the Commissioner for the ALRC inquiry, and we're very pleased to have him join us here today. Can I begin by acknowledging the traditional owners of the lands on which I sit. I'm here by the Yarra River, on the lands of the Wurundjeri people of the Kulin Nation, and I extend my respects to their elders past and present, as well as our respects to the traditional owners of all the lands from which we are all attending across Australia. Before I pass over to Tony, let me say some brief words about the ALRC and this inquiry. The ALRC is in its 50th year this year, 50 years of providing expert evidence-based law reform recommendations to government. The inquiry into the Future Acts regime is indeed an important inquiry. It comes at an important time. We are busily involved in research and consultation for that inquiry. We are now in the second phase of our consultation processes, where we are consulting essentially in relation to ideas that we have developed, ideas for reform. In this process, we are testing those ideas, and the purpose of this webinar is to give people who may well be affected by the law and any law reform the opportunity to help us to identify the right recommendations, the best recommendations that the ALRC can possibly make. The ALRC, I think, can be credited with pioneering our consultation processes, or the consultation processes adopted by law reform agencies across Australia. We regard consultation as crucial. We appreciate the importance that your insights and your observations bring to our process. It's part of what we call evidence gathering, part of our evidence-based approach to the conduct of our law reform inquiries. The main purpose of today's webinar is to outline some of the options for reform that we are thinking about and which are spelt out in our discussion paper. I thank those of you who have already submitted questions in advance, and I want to encourage all of you to put forward any other questions you might have during today's webinar. You can either use the chat function, or you can do that by email to native title, or one word, at alrc.gov.au. We'll do the best we can to answer your questions during this session today. Can I, without further delay, ask Tony to introduce himself and the other members of our team who will speak and commence our discussion. Over to you, Tony.
Thank you, President. My name's Tony McAvoy. I'm a senior counsel practicing at the Sydney Bar. I'm a Rooty man from Central Queensland and have been involved in the native title practice for over 20 years. I was appointed as a commissioner to the ALRC in about July last year, specifically to deal with this particular referral. Mordy and I are supported by two other speakers who will be on this webinar today. Assistant Commissioner Nick Testro, who you will see at some point shortly, and Shanti Fatchin, who is a Senior Legal Officer. We have been blessed, I think, with a great team, and it's been a pleasure to work with the team at the ALRC. So what we have been able to do in the time that the inquiry has been running is release an issues paper, and then more recently issue a discussion paper outlining some potential reforms to the Future Acts regime under the Native Title Act. We are going to use today to give some overview of the key reforms in the discussion paper and answer any questions you may have about them. As we are speaking, please feel free to submit any questions using the chat function, as Morty has already said, or email us at nativetitle at alrc.gov.au. Now, we are at a very important point in this inquiry where we are seeking feedbacks and submissions about some potential reforms. In the discussion paper, we have done our best to set out some reforms that we see as potentially possible, but they are very much still works in progress, and we're seeking feedback and submissions about them and about other matters that we may not have addressed in the discussion paper but are relevant to the terms of reference. We are looking to deliver a final report to the Attorney-General on the 8th of December this year, in accordance with the terms of reference. As many of you are probably aware, the Future Acts regime is quite complex, but it is only just one part of the Native Title Act. The referral to the ALRC has requested that the Future Act regime be reviewed with three things in mind. Firstly, the efficacy, the efficiency, and then the fairness of the legislation. In the issues paper we released in December or November last year, we asked what an ideal Future Acts regime might look like to stir people's imaginations and perhaps our own. And that really is the central question. This particular form of the Future Acts regime has been in place for some 27 years, and we are conscious of the need to try and put forward some recommendations that will guide the system in a fair manner over a lengthy period of time in order to give everybody certainty. Now, we ask you to remember, though, that whatever interest holder you are in these particular reforms, whether you're a traditional owner or government or a body that represents proponents, you keep in mind the other parties' views and perspectives about these matters, to assist you in preparing your submissions. Before we get into the potential reforms, we think it might be helpful if Shanti provided some framing about what Future Act is, and also to point out some of the areas that we've focused on. Are you there, Shanti? Yes.
Thanks, Tony.
Thank you.
Good afternoon, everyone, and thanks for joining us. So, as Tony said, we thought it might be useful just to outline some of the basics. So, what is a Future Act? A Future Act is an act that affects native title. If we consider it in that framework, that's probably the most simple way to describe it. For those who are a bit familiar with native title, there's obviously a formal definition that it is an act which extinguishes native title or wholly or partly is inconsistent with the continued exercise, enjoyment, and existence of native title rights. Common examples are the grant of mining or exploration tenements, pastoral leases, water licenses, compulsory acquisitions. So what we've been asked to look at is the entire scheme, not just one element of the Future Acts regime. Why is reform needed? Very good question. I think, as Tony mentioned, this system has been in play for a while now. The current Future Acts regime has largely been untouched since 1998. And if we look at how the field of native title and the landscape was back then, it's changed hugely since. Back then we were talking about 5 determinations that native title exists. Now we're talking about over 500. So we would like to see that some of the learnings over the last few years are captured and are considered in what the best Future Acts regime would look like going forward. What we've heard throughout the inquiry so far is that native title law is complex. The system is expensive and difficult to use. Native title holders don't always get enough say in the processes in relation to the acts affecting their country. And fundamentally, the big one is that resourcing is a huge issue that touches almost every aspect of the regime. Our key ideas for reforms, there are 3 main ones. One is reforming the statutory procedures, and I'll talk to that aspect. Nick Testro, our Assistant Commissioner, will talk to agreement making and the reforms aimed at promoting fairer and more equitable agreements. And then Tony, our Commissioner, will talk to you all about the native title plans, which are a new idea that we've come up with, and we're quite keen for your feedback on them. So this is how the current Future Act statutory regime works. You've got, when government is proposing a Future Act, they need to work out under which of these categories it fits under. Unfortunately, there's not a common theme throughout the provisions. Sometimes it's based on the industry, sometimes it's based on the underlying tenure, sometimes it's based on the purpose of the Future Act. It really does vary throughout the sections. And also what varies are the rights that native title parties have, from a right to only be notified through to a right to comment, a right to negotiate, and a right to object. On the left-hand side, you've got some bubbles about what we've heard from parties in relation to the current scheme, that it's overly complex and ambiguous. And keep in mind, this is feedback that is coming from primarily legal practitioners experienced in the area. So when we're thinking about the Future Act regime, it's typically departmental officers who are applying it, trying to work out where a Future Act fits. So if lawyers are saying it's complex and ambiguous, it's a really big ask for government department officers. Also, we've heard that this type of framework doesn't consider the scale or the scope of the Future Act. So a Future Act which involves the construction of a new pipeline versus the maintenance of an existing pipeline carries the same rights for native title parties. It's also fixed in time and doesn't consider new and emerging industries. These, as I mentioned earlier, these categories were set in 1998 and there has been very little amendment since. We've also heard that there's an inconsistent application of these sections across state jurisdictions, but also within jurisdictions when different departments are applying the categories and where a Future Act falls within. The most fundamental issue for us, though, is that there's this real misalignment between the impact of the Future Act and the rights that are granted for native title parties. So what we're proposing is to essentially realign the impact of the Future Act and what that impact will be on native title rights and interests. Flowing on from that will be the rights afforded to native title parties. The thinking is the higher the impact of the Future Act, the greater the right for the native title parties. For those familiar with native title, this may look quite similar to the inconsistency of rights test used in determining when native title is extinguished by acts. The way the model works is that a party, usually a government party, proposing a Future Act will assess the impact of that on native title rights and interests. That assessment we've suggested be based on factors that may be included in guidelines, but it may include things like the nature of the act, the size, the duration, the long-term effects, as well as the location. For example, where it's on exclusive native title or where it's known that it is an area of cultural sensitivity. The model is focused on the rights granted as part of the Future Act rather than the proposed activity. In other words, if the Future Act is a water licence, which includes the right to take 1 gigalitre of water, that will be the impact that's assessed, regardless of whether only 500 litres of water is taken. Again, those acts assessed to be lower impact will be subject to a right for the native title parties to be consulted, and those deemed to be a higher impact will be subject to the right to negotiation. It's worth flagging here just very briefly that there are potentially types of Future Acts that may not be appropriate to be subject to this assessment. We've noted them in our discussion paper, but they're things like where a government party is seeking to compulsory acquire native title rights and interests, or Future Acts that are legislative acts. Now, we do admit this is quite a change from the current model, but an impact assessment model is not completely unfamiliar in the legal world. It's used in national environmental law, some state cultural heritage regimes, national park legislation, and resources law. I'll quickly hand over to Assistant Commissioner Nick, who will talk us through what is meant by the right to consultation, the right to negotiation, as well as he'll detail our proposed reforms to agreement making. Thanks, Nick.
Thanks, Shanti. Good afternoon, everyone. Thanks also from me for joining us in this session. As Shanti touched on, the proposal that we've put up includes a right to consultation and a reformed right to negotiate. The right to consultation we're proposing would require an exchange of information and for the proponent to seek the views of the native title parties in relation to the Future Act. Where possible, where practicable, the proponent must the decision maker must respond to those views, and there must be then engagement between the parties to minimise the impact of the Future Act on native title. One of the other things that I want to touch on before turning to what the right to negotiate might involve is some of the issues that we've heard in relation to the existing expedited procedure and right to negotiate, which are two of the key processes that are used predominantly for mining tenements and mining rights and interests. In relation to the expedited procedure, we've heard that even where it might be supported in principle, it's not functioning well. And the expedited procedure, despite its name, is not often expedited, where it must go through an objection process, and that process can take 18 months. We've also heard that that there's concern that there's no assessment of a particular grant against the criteria in Section 237 of the Native Title Act, which must be met for the expedited procedure to apply, which means that the state or territory that applies the expedited procedure is asserting the expedited procedure in areas where the criteria are unlikely to be met. States and territories, we've heard, are also applying the expedited procedure in areas where the tribunal has previously held that an objection is valid, meaning that the expedited procedure doesn't apply. We've also heard that the way that the expedited procedure criteria have been interpreted, the onus is on the native title parties to demonstrate how the criteria under Section 237 aren't met, and that causes distress and fatigue on an ongoing basis for native title parties. And also a fairly significant issue is that we've heard that objections are often made by native title parties in part at least to achieve a better outcome under state, the applicable state or territory heritage law. And perhaps more from a systemic perspective, we've also heard concerns that the expedited procedure sets up an adversarial process from the outset, meaning that it can be very difficult for a proponent and native title parties to foster a positive relationship, particularly if they have to go down the right to negotiate. I'll now just quickly turn to some of the issues that we've heard about the Future Acts determination application process, which is a process under the right to negotiate. We've heard that the statutory timeframes are too short. The minimum 6-month good faith negotiation timeframe is too short. The Section 39 criteria that the Native Title Tribunal have to take into account in making a determination and how they've been interpreted almost inevitably result in a determination in favour of a proponent, in favour of a tenement being granted. And there are only 3 or so instances where out of more than 500 that the Tribunal has made in favour of native title parties. We've also heard concerns about the good faith negotiation requirements, and that those threshold requirements are too low. We've also heard native title parties are concerned that they don't have an effective ability to say no to a Future Act. They're effectively required to go straight into a negotiation about the terms and conditions of the grant of the tenement without any ability to say that they don't want it to go ahead at all. And finally, and relatedly, the native title party's bargaining power is limited, where if a native title tribunal determination is made, there's no ability for the determination to award any kind of payment for the doing of the Future Act. So now turning to what we're proposing to do to reform the right to negotiate. And as Shanti noted, this would apply to higher impact Future Acts, so what we classified as Category B Future Acts. The initial step is that the Future Act is notified, and then the parties are required to, and predominantly the proponent is required to provide information to the native title parties about the Future Act to enable the native title parties to determine what their position will be on the Future Act, whether they should object to the doing of the Future Act or negotiate the terms and conditions of the doing of the Future Act. If they object, they can do so within a period of 6 months from notification, and then the proponent or the government party that will grant the tenement, if they still want the Future Act to go ahead, they can apply to the tribunal to have the objection overturned. We've proposed three different ways, three different tests that the tribunal might be able to apply in determining the objection. The first is whether the objection would constitute unreasonably withholding of consent by the native title parties. The second is whether the Future Act would cause, whether there was a real and substantial risk of substantial and irreparable harm to the native title rights. And the third would be a tweaking of the existing Section 39 criteria. If the tribunal determined that the Act can't be done, then that's the end of the matter, subject to any appeal rights like judicial review. But if the tribunal determined that the Future Act can be done, then the parties would then need to negotiate the terms and conditions on which it could be done. And we're also proposing that as part of that process, the tribunal would be able to, the parties would be able to refer separate questions to the tribunal to resolve any impasses in the negotiations. Then finally, if the parties can reach agreement, then that's the end of the matter. And of course, any conditions that are part of that would need to be complied with for the grant. If the parties aren't able to reach agreement on any or some of the conditions, then they could apply to the tribunal for the tribunal to make a determination. And the tribunal would be able to determine whether any payments should be made as part of the grant of the Future Act. I'll now turn to the next topic, which is agreement making. And I'm conscious of time, so I won't spend a lot of time on this. The key aspects of our agreement making proposals are really about amending and reforming the existing system. We're not looking at an entire overhaul at all. We're looking at plugging gaps, making improvements to the existing system to help it work better, and to make improvements where people have identified deficiencies. We're proposing that there would be conduct standards that would apply in the negotiation of agreements, and that would include things like an obligation on the parties to negotiate in good faith. So that would apply to ILUAs as well as right to negotiate agreements. There would also need to be a freedom of coercion in the negotiations. Proponents would need to contribute to the native title parties' costs as part of the negotiations. We've heard a lot about delay and issues in the parties even commencing substantive negotiations while due to an inability to reach agreement on costs. And also going back to that issue about information, there'd be an obligation on proponent to and states to provide information to native title parties, and for native title parties to also provide information. For content standards, some of the things that we're proposing include the prohibition on certain clauses within agreements, like gag clauses. We've heard a lot about that coming out of the Duke and Gorge report. And a prohibition on constraining native title parties from exercising rights under other laws like cultural heritage laws. We'd also mandate the inclusion of a dispute resolution clause having certain characteristics. This might include, for example, a mandatory referral of any issue that can't be resolved by mediation to arbitration by the Native Title Tribunal or another entity. One of the other issues that we've talked about in the discussion paper is whether there's support for expanding the ability for PBCs to seek instructions from the common law holders under a standing instruction arrangement, so that the PBC can enter into a wider range of agreements than is currently permitted under the PBC regulations. For example, we've proposed low impact ILUAs, and low impact, in particular, low impact exploration ILUAs. I think I'll leave it there just in light of time. I'll now hand back to Commissioner Tony McAvoy to talk us through native title management plans. Thanks, Tony.
Yeah, thanks, Nick. You'll be pleased to hear that I'm the last person to be speaking to you, and then after this we can get into some questions. Native title management plans is it's a term that we've established ourselves just in order to have a working label for the concept. The idea is that it gives PBCs a primary role in setting up Future Acts rules for their particular territory. Positive experiences of Future Acts regimes that we've heard about have almost always involved early input from native title holders and engagement with that input. So we see the management plans could be a way for native title holders to be proactive in the respect of the management of their land rather than responding to Future Act applications. The idea, we think, also draws on there being some regional differences and issues, so that it avoids a one-size-fits-all approach. In the discussion paper, we've introduced the idea and the principles behind it, but there's a lot of work to be done, and we expect that the ideas in their implementation can be very highly tailored and specific to the law and custom and aspirations of the prescribed body corporate that is adopting those plans. The plans could, for example, set out how Future Acts are to be done, make more robust or streamlined processes for particular types of Future Acts, or in particular areas of country, provide for indication of sensitive cultural areas, including using mapping where appropriate, and if, for instance, as we've heard from a number of people, there's interest in promoting economic development, it would be possible, for example, to identify what type of development might be supported in particular areas, and the nature of that development. It could also, we believe, provide a catalogue of the services that the PBC could offer proponents when they are doing acts on country. In terms of how they fit with other processes, when a Future Act is proposed, prior to granting the Act, the government party would check to see if there's an existing Indigenous land use agreement, and if there isn't, then whether there is an NTMP which is applicable, and then if there are neither of those, then the statutory procedures which Nick discussed earlier would apply. The native title management plans we're suggesting should be registered with the NNTT, and the question of what that registration looks like is something we would like to hear from you all. The registration process shouldn't be about making NTMPs difficult or inaccessible to have registered and enforceable, but we accept it, and we suggest to you that there should be some guardrails around those NTMPs. So a key issue for the NTMPs is the need to for resources to develop them. We know that not every PBC might be in a position to develop an NTMP, and it's been suggested that that representative bodies or land councils could play a role in assisting PBCs. But we ask everybody to note that it's not mandatory for a PBC to have a native title management plan under the proposals that we've put forward, but they do represent another tool for native title parties to communicate their wishes and expectations and provide clear paths and greater certainty for other parties. So we're interested in hearing what you think about NTMPs as an idea, how it may work in practice, any related type experiences you might have. In particular, we are keen to understand what you think should be included in them and what shouldn't. We'd also like to hear your thoughts on the criteria for registering NTMPs. It hasn't been possible for us today to cover all the ideas included in the discussion paper. It's quite dense, and there's a lot of material that's covered. So I encourage you to all read through the discussion paper when you can, hopefully very soon, and particularly those areas in the discussion paper that focus on compensation and other payments, resourcing and cost to the system, or the costs of the system, and also our observations regarding cultural heritage. Now, I'm going to hand it back to Shanti to facilitate the Q&A. Are you there, Shanti?
I am. Thanks, Tony.
Thank
Nick,
you.
if you're happy to join us as well, we're getting some great questions in the Q&A section. If you please keep sending them through. Tony, while we've got you just talking about the native title management plans, I wonder, has the Commission considered the level of consent or consultation that PBCs will be required to undertake in relation to NTMPs?
It's assumed that it would be something that would be supported by authorisation. As from my perspective, it's because it may have the effect of establishing a compliance regime, which would then permit the government to fast track or issue a grant on the basis of compliance. It seems to me that it's going to need authorisation.
Great. Thanks, Tony. We've got a couple of questions about the impact assessment, which I'm happy to take. So one question is it proposed that the impact assessment will be based on the highest use / exercise of the full rights? Yes. We think that that's the most fairest way for the impact assessment to consider, rather than considering what the proponent is proposing to do under that grant. We've got another question about will the low versus high impact assessment model be self-assessed, meaning it is up to the proponent to decide, or is there some other mechanism to ensure the Future Act is being correctly categorised? So it's actually going to be up to the party who is proposing the Future Act. So in most cases, that will be the government party granting an interest. We have in the discussion paper talked about native title parties having the ability to question or challenge that categorisation, noting that some of the information will only be held by the native title parties themselves. For example, if there's a sensitive cultural site, or if they have concerns about multiple acts already occurring in that area. Just moving now to a question about transparency and NTMPs. So, Tony, in the interests of transparency, shouldn't all sacred sites be mapped in an NTMP so that it is visible on the NNTT register?
I have assumed that in creating the NTMPs, PBCs will identify areas which are areas in which development would be opposed because of the existence of sensitive places, and that can be done in a way that that would not disclose the exact location, but identify the area that is subject to concern, and so that would be assuming. I assume that would include all sites, sacred sites. Have I answered the question, Shanti?
I think you have. Thank you, Tony. We've received another question. We obviously had a slide talking about cultural heritage, and our discussion paper touches on it. I'm open to hearing whoever would like to answer this question. But the question is, given the existing federal review of the Aboriginal and Torres Strait Islander Heritage Protection Act, how are the two processes going to interact or align?
I'd like to think very closely, Shanti, but it's difficult, of course, as most people will understand. The primary cultural heritage protection mechanisms are all under state and territory legislation, and the Commonwealth Heritage Protection Act really is a backstop to those state and territory pieces of legislation. It may be possible for some accreditation of of particular actions or mechanisms as being satisfactory for the purposes of the federal legislation, but how we make that linkage to state and territory legislation is difficult. And if anybody's got any ideas on how to do that, we would like to hear from them.
Thanks, Tony. Just Nick, while we're talking about state legislation, has the Commission considered all of the various state-based schemes in terms of resource law, environmental protection, etc., and how the proposals will interact with those schemes?
Thanks, Shanti. Sadly, we don't have a lot of time to be able to go into other laws of the states and territories to any great degree. I mean, it's obviously a very relevant point, given that that states and territories are the ones that are predominantly implementing the Native Title Act. But also, I suppose, in addition to time and resourcing, it's a question of whether it's within our terms of reference, where obviously the Australian Law Reform Commission, which means that we're a Commonwealth entity, and we're looking at the Commonwealth Native Title Act. And so while we can obviously take into account the way the Native Title Act is interacting with state and territory laws, we can't influence any law reform at that level. So yeah, I think that's my response there.
Great, thanks, Nick. Just on while we've got you off mute, oh, you just put yourself on mute. Just in relation to agreement making, a question has been asked about whether a conduct standard will be that the proponent funds the negotiations or funds the meetings, etc.
Yes, that is one of the proposals. I think I noted in the presentation that that the negotiations about costs can often take up a large part of the initial part of discussions and detract from the actual substantive negotiations. But we're also talking about we're proposing amendments to the costs framework within the Native Title Act. We've heard there's a lot of uncertainty and from the proponent's perspective and a very broad range from what native title parties can ask. So we know that the costs regime isn't really satisfactory from anyone's point of view at the moment. So we're proposing to put in place a lot more structure around that. And I think that what we've heard as well, just to note, is that on the whole, proponents do accept that they should be contributing to those costs. So it's more a question of how that's done rather than the principle as such.
Thanks, Nick. Tony, I might turn back to you about an NTMP question. So have any impacts associated with NTMPs specific to critical service delivery and infrastructure projects been considered as part of the regime and the proposal? Sorry, Tony, it looks like you're still on mute. We knew it would happen.
So, sorry, not in terms of specific criteria for NTMPs. We're working on matters which might form. I think I referred to them as guardrails, and whether there needs to be some provisions which are automatically provided for an NTMPs. There are a whole host of questions such as this one, and they'll all have to be considered as to how they can be accommodated.
Thanks, Tony. We've got another question about NTMPs. Will the ALRC consider making recommendations that states and territories consider how to link management plans to their cultural heritage and land rights processes?
Well, I'm not sure. We can't really make recommendations to the states. Our recommendations are to the Commonwealth, but certainly there are aspects of these proposals in terms of all aspects which may influence the way then states and territories operate. And what we can do is make recommendations about a system that's effective from the standpoint of the parties interacting in the system, and people will adjust themselves as state parties, PBCs, proponents will all adjust themselves to the new system, whatever it may be. But we have been talking with state agencies and heard their support and concerns and ideas, and so we're doing our best to take those matters into account.
Thanks, Tony. Nick, I wonder, in relation to the right to consultation and right to negotiation, can you comment on how those concepts comply with free, prior and informed consent?
The right to consultation is probably outside of that concept. I'm not sure that it does, and the reason for that is that we're trying to provide a practicable two-tier process, and we're lifting up the minimum process requirements as they stand at the moment. So obviously the current under the current regime, the minimum procedural requirement, if in some cases there is none, but the minimum otherwise will be a notice and opportunity to comment. So the right to consultation then, where the native title parties are required to be notified, provided with information about the Future Act, and then for their comments to be genuinely taken into account in the grant of the Future Act and the doing of the Future Act. We consider that to be to a higher standard, so something that is going to be closer to that FPIC principle. For the right to negotiate, I set out before the three, firstly, there's an ability for the native title parties to object to the doing of the Future Act as part of that first stage. And then the tribunal we've put up three different options for the test that the tribunal would apply. So just to recap, that whether the native title parties have unreasonably withheld consent, whether there's a real risk of substantial and irreparable harm to native title, or a tweaking of the Section 39 criteria, any of those could potentially be applied in a way, and you'd have to I think to specify this in the Act. Could have an element of FPIC in them. So, for example, you could say that where it's exclusive possession native title and it's a high impact Future Act, then it wouldn't be unreasonable for the native title parties to withhold their consent to the Future Act. Or if there's a site of significance that will be affected by the Future Act, and there's no mitigating condition that will be imposed on the Future Act. That might be another basis on which it would be reasonable for the native title parties to withhold consent. So while we're not including what, and I suppose it depends on your conception of FPIC. So if you conceive of it as a right of veto, we're really not including a right of veto as a primer, I guess the headline principle, but there may be circumstances in which it would be reasonable for the native title parties to say no. So we want to hear from people about that, because that's an open question.
Thanks, Nick. We've probably got time for one more, and I'm very sorry, there are a lot of questions coming in, so please feel free to email us afterwards. How will consideration of the views in the proposed right to consultation and negotiation pathways be assessed? Will it be something similar to the good faith negotiation criteria by the NNTT currently?
To be honest, I can't recall if that's something we've put a lot of consideration into at this stage. I think that's probably right. I think it would have to be something that's considered by the tribunal as part of their its determination under that pathway that we showed up on the slide previously.
Great, thanks, Nick. Morty, I might hand back to you, and just thanks to everyone for your questions. It's been really great.
Thank you, Shanti. Can I reinforce our thanks to the many of you who've participated. Thank you for your questions. Those that haven't been answered, we'll do our best to try and answer them. You can keep them coming. What we're really interested in is receiving your submissions. Submissions close on the 10th of July, so there's not a lot of time, but we'd like your submissions. As I said earlier, it's critical to our tasks that we have the observations and insights of those of you who are likely to be affected by the law in particular. I should also mention that if you want to maintain confidentiality, in relation to your submissions, please indicate that and we will respect your request for confidentiality. Can I also say that you can make submissions through the ALRC website or by email to nativetitle@alrc.gov.au. Thank you for our speakers. I hope, I know that they've given all of us some more insight into our thinking. Of course, the discussion paper has a lot more of the detail, so I would encourage those of you that haven't had a close look at that to do so. Thank you for attending, and I will close the session now. Shanti, if you want to do that. Thank you.
Thank you, everyone.